Hello everyone. Welcome to the CGQP Examination Technique Workshop. This is part one for Hong Kong Company Law. So my name is Ian and I'll be taking you through these different workshops. So before I begin, just some disclaimer. The aim of this workshop is for exam technique for the upcoming Hong Kong Company Law paper. We will be going through some of the past exam question for illustrative purpose only. So it's not to be taken as indicative of the actual exam. In other words, I do not know the content of the upcoming exams, so I'm just using the past exam questions for illustration purpose. That's all, okay? That's the main thing I want to say. This is the agenda. I would go through review the scope of the paper. Well, basically, you have your syllabus, your learning outcome. I'll be going through each one of them, provide some explanation. Then I'll be talking about exam format, approach to answering legal questions, and I will also finish off with some practice question. So this is a first of a series of workshops. So hopefully you find this helpful, and then afterwards maybe you can get yourself ready for the subsequent workshops. Okay, so first of all, the scope of the paper. So I extracted all these information from the HKCGI website and also from the relevant materials. So I think you would recognize this is the cover sheet for the Hong Kong Company Law paper. So most important is look at the part I highlighted. The total study time is 200 hours. So that is very important. What is it trying to say is, as you might know already, there's a lot of content for Hong Kong Company Law. It covers many different areas. So that's the reason why you will need to spend sufficient time to make sure you cover all the different topics to have enough understanding so that you can tackle the exam paper. Okay? Of course, the exam paper will not examine every single topic. But since we do not know which topics will be examined, that's why it's important you have a good coverage, meaning have an understanding of the different topics so that you can be more or better prepared. So I also understand many of you are part-time, I would say, meaning you're working at the same time in addition to preparing for the exams. So naturally, your time is limited. You will have to manage your time properly. I do understand that myself because I studied many courses part-time as well. So my own suggestion is it's good to have a study plan. What is a study plan can be very broad, but generally speaking, you would want to have a schedule. For example, I know some students, every Saturday or every Sunday is study day. So if you are busy with work Monday to Friday and you need to prepare for an exam with so much content, then you will need to designate certain days which will be your study day. So it's entirely up to you based on your own schedule. Some people is every Sunday, some people is Saturday, it just depends, or maybe half a day on Saturday, half a day on Sunday, who knows. But if you do that from the very first week, you can imagine every week you would spend, I would say, 20, 30 hours each week preparing, okay? Assuming you do take a bit of time on weeknights as well. In that case, after 1 or 2 months, you have already logged in over 100 hours. So that's the reason why I would suggest from the very beginning, try to designate certain days and time period in which you want to do preparations. Okay, so let's take a look at the aim of the paper. So aim of this module is to provide a thorough grounding in and knowledge, a thorough grounding in and knowledge and understanding of the legal framework governing certain business organizations with particular focus on a registered company. So I think at the earlier part of the syllabus, we will look at different business structures, different vehicles, if you will, to conduct your business. But then I think for the rest of the syllabus, it will focus mainly on the registered company, the limited liability company. So hopefully that's something we can achieve. Where appropriate, the module covers relevant corporate governance topics and the relationship between company law and corporate governance. So corporate governance is very important, as It's very important for companies, but it's even more important if you're a publicly listed company for obvious reasons, because you are actually managing the company and managing the business on behalf of a lot of public investors. So this is a very important topic. As you may know, there were recent updates to the listing rules because of corporate governance, which improved many things on how they manage the company and how they set up the committee, etc. So corporate governance and company law do in fact go hand in hand. And that's the reason why some of those topics will be covered as well. Okay, learning outcomes. So learning outcomes is basically more specific. We have the general objective, the general requirements, but then the learning outcome can give you a more specific and clearer idea what you would like to achieve after you've completed this particular course or this particular paper. So number one, demonstrate an understanding of the legal framework within which commercial organizations operate, their business structures and corporate personality. So company law. So obviously the legal aspect is important. Legally, which business structure you can use, how you can operate in a commercial setting, and of course the corporate personality is talking about the company itself. Because as you may know, the company under company law is a separate legal person. So it is a corporate personality itself. The second learning outcome, demonstrate an understanding of the roles and statutory duties of directors, as well as the composition and structure of the board. So who runs the company? Especially if you have a company of many shareholders, most likely you will have someone who are directors of the company who you would appoint, and they would manage the company for you. So they do have a very key role and function, but more importantly, they also have statutory duties, legal duties, if you want to describe it that way. And it's basically they need to follow these requirements in order to manage the company properly, basically for the benefit of the company as a whole. And then, of course, the composition and structure of the board. In most cases, anytime in company law, when they say the word the board, they mean the board of directors. Okay, so that's why when we talk about directors, you see plural is talking about the board of directors. It is one of the two key organs of the company. And the board of directors is basically the one managing the company, and they do have the authority and the power basically to make a lot of decisions on behalf of the company. The third learning outcome, demonstrate an understanding of the internal rules and external regulatory environment which companies are subject to regarding membership and protection and remedies for members. So learning outcome 2, we talked about directors. Learning outcome 3, we talk about members. Okay, so members, for example, shareholders, they are the one who basically own the company. Each of them will own a share of the company. So of course, if they are the one who do own the company, but they are not the one running the company, then you need some rules and regulations, basically to constrain what the directors can do or cannot do. So those are the internal regulations, which we'll talk about very soon later on. Of course, if something do go wrong, and unfortunately they may, then you need to look at protection and remedies for members. Protections. What rules are in place to protect the interests of the members? Remedies is if something do go wrong, what happens? What can you seek? Which remedies can you seek? Can you ask the court to stop the directors from doing what they are doing? Can you ask the court to reverse some of the decisions of the board of directors? Or can you ask the court to do something to maybe get some money back that was inappropriately taken out from the company's asset? So those are examples of remedies. Okay, so let's now look at learning outcome number 4. Apply relevant legislation, case law, and best practice recommendations to legal and governance issues arising in complex scenarios relating to shares, capital maintenance, and loans. So let's look at this one part at a time. So relevant legislation. So legislation basically means the ordinance in Hong Kong. Okay, the the law that as we know. So for example, the Companies Ordinance, CAP 622, is an example of a legislation which most likely we'll be referring to a lot during this part of the course. Now, case law. Let's talk about the decisions of the court. So as we run under a common law system, so the decision of the court it forms part of the body of the law for us under a common law system. So you do follow the legislation, but sometimes the courts, they will make a decision that help us better understand, for example, how to interpret a particular section in the law. When they make a particular requirement, what exactly do they mean? And in a particular situation, how would that apply? So court decisions are very helpful. Then you also have best practice recommendations. So for example, the Guide to Directors' Duties issued by the Companies Registry, that will be an example where you have the best practice that is given. There's also the code, the CG code, Corporate Governance Code for the listing companies. There are also very good recommendations. Obviously, CG code have a slightly higher status because listed companies are expected to comply. It's not just it's recommended, you can choose to comply or not comply. Okay, then legal and governance issues. So legal, of course, legal issues is talk about whether you're complying with the law. There's a requirement by the law you need to follow. Governance issues is where you have the CG, the corporate governance. And then, of course, we talk about complex scenarios relating to shares. So for example, if you want to transfer shares to someone else, what if the directors do not agree? As a shareholder, as an owner of the shares, what can you do, or do you have no say? Other issues that may arise for capital maintenance. So for example, it is actually written in the company's ordinance that you must make sure you have capital maintenance, meaning maintain your share capital, which one of the main reasons is to protect the interests of the creditors. Okay, so even though we focus mainly on directors and shareholders under company law, creditors are very important as well, their interests, especially if the company is not doing well financially, especially if the company is not solvent, meaning not enough money to settle their debts, then capital maintenance is very important. And for loans, of course, it's important because it's agreeing to lend or lending money out. And in that case, it may affect the interest of the shareholders. So for example, if the directors, they authorize some loans to a company that they own, a connected party, then there must be certain procedures to make sure it is disclosed, and must be certain procedures to make sure there are approvals by the shareholders in order to protect their interests. Okay, to the fifth learning outcome. Apply appropriate judgment when presenting advice on structural and legal issues in relevant form, for example, corporate restructuring, liquidation, and dissolution. So you have a company, sometimes, as I mentioned before, they may not do well financially, then you may need to look into what you can do about it. Is it possible to rearrange its affairs, rearrange some of the shareholding and some of the decision making in order to save the company? So sometimes you have corporate restructuring, but sometimes you cannot. Sometimes you believe the company is insolvent, meaning not enough money to repay all their debts. In that case, it may be necessary to put the company in liquidation. So liquidation is a formalized process where you want to basically put the company to an end, but you cannot just close down a company. There are still legal obligations, rights and obligations, and you must make sure, for example, the debts that are owed to creditors are repaid or repaid as much as possible before you close down a company. And dissolution is where you actually do dissolve a company. All that may come up if you decide you no longer need to use the company or your business has come to an end. Okay, so let's break down the learning outcome to even more specific details. So you can see here under learning outcome 1, we have the different topics. These are all extracted from the syllabus. And then we've done that for learning outcome 2, outcome 3, and then all the way to outcome 5. So there's a total of 5 learning outcomes, and it's possible to categorize each of those different topics under a particular learning outcome. So what I plan to do is to go through them one at a time to give you some explanation so that at least you have a general idea. So let's say you just enrolled for this Hong Kong company law and you want to start preparing. So it's a good idea to have an idea, the coverage, the different topics that will be covered. So the very first topic under Learning Outcome 1 is the source of company law and governance. So this paper is called Hong Kong Company Law. So it has to follow the laws for companies. But where do those laws come from? In other words, if I want to find out more about those legislation, for example, where do I look? Which one do I look? So they're all right in front of you right now on the screen. First and foremost, of course, it will be CAP 622. This is called a company's ordinance. So a lot of times we'll be referring to this one, okay? It contains, I think, over 900 sections. So it contains a lot, has a lot of sections in it. But I think in order to have a good understanding of all the different topics, you will not need to know every section. So that's a partial good news for you. But of course, and unfortunately you may hear this, is 622 is not the only ordinance you need to look at. So sorry about that. You also need to be familiar with CAP 32. So that's the second one. Okay. So most of the matters you will look at CAP 622, Companies Ordinance. However, for two areas. So for example, if you want to issue a prospectus, okay, you want to invite people to subscribe for your shares. A lot of provisions relating to that topic will be in CAP 32. Also, we just talked about liquidation. So a lot of the sections relating to liquidation and insolvency and restructuring, all that will be in CAP 32. Okay? Now, that's just the first two rows. Let's continue now to the third one, case law. I talked about this briefly just before. So these are all the decisions of the different courts on these company law or related topics. Of course, there are hundreds, if not thousands, of court cases and court decisions. Probably not possible to memorize all of them, but I think also not necessary. I believe the materials you have provided by the Institute, the study materials, they are very helpful, and it most likely will be grouped by topics. So for each topic, there are bound to be some major landmark court cases. So those, of course, you should be familiar with, okay? So you should at least know, okay, what's the main principle from those court cases? So for example, the most famous court case for company law must be Salomon and Salomon. And famous court case, the principle from this famous court case is that there is the separate legal entity principle, okay? If you properly form your company, have it registered under the ordinance, then the company will become a separate legal person, which is separate to the shareholder, separate to the owner, separate to the directors and the people involved. So that's the whole point of setting up a company. You have a separate legal entity. So hopefully that's a simple example to show you about case law. They're very helpful because they give you these clear principles that can help you to apply into different situations. So I think, okay, by topic, you should be familiar with the major landmark court cases. Is that it? Probably not. I will probably go a bit further. The landmark court case normally, for each topic, will give you the general principles. Okay, you have a separate legal entity. Let's continue with this example. Okay, but of course, quite often there are also exceptions to the general principles. So using this example, I set up a company. So the company and the owner, let's say me, we are separate legal entity. The individual, the company is separate. Okay, but there can be exceptions, meaning there can be instances where the court will decide to pierce the corporate veil, meaning go right through the company and you can become personally liable. Okay, so the court cases for those, of course, you must know. Okay, because it's an exception to a well-established general principle. So for myself, when I did my studying, I make sure at the very least, I know the court cases for the general principles and the court cases to the exceptions of general principle. Now, if you have more time, you can cover more specific case, wonderful. I'm sure they're all in the study materials. But if you are running short in time or you're just not too sure if you're able to cover all of the cases or all of the contents in the study materials, at least start with these first. That way, I think you have a good grasp of the principle of all the different topics, so that no matter which topic is examined this upcoming exam, at least you are able to start answering those questions or maybe even complete answering those questions. Okay, so that's for case law. Let's now move on to the next one. So for company law, you must have the company's ordinance. If you are starting or ending a company, you must have Cap 32, you must have case law. But then you have the Securities and Futures Ordinance, SFO. Okay, so you wonder how come another ordinance? Well, you do not need to know every single part of that legislation. Okay, it's just certain part. In particular, I think market misconduct. I think you have a topic on insider dealing. The legislation is from the SFO. So that's the reason why we looking at that when you look at that particular topic. Then, so far we have looked at the principal legislation, Companies Ordinance, Cap 32, and SFO. These are the one with the general, the main requirements, what you can do, what you cannot do. But then you do have subordinate legislation, okay? So imagine the principle is decided, the Legislative Council already passed, you have the legislation at hand. But when it comes to implementation, the day-to-day matters, how to do it, what are the step-by-step procedures and requirements. In those situations, you will need subordinate legislation, which basically give you the detailed rules, which are very important, okay? So having these information, I think you will at least have a good grasp of the legal requirement, and these will be the source of company law. Okay, so those are the main ones. So what about the remaining one? What are they? Okay, so you also have listing rules. So as you may know, a company may be a private company, but it may also be a publicly listed company. So if it's listed on the exchange, for example, on the main board of the Stock Exchange of Hong Kong, then of course you must comply with the listing rules. So that's why for certain matters, you need to look at those. So for example, I just talked about insider dealing. So there are certain provisions on maintaining confidentiality of inside information that's part of the listing rules. There's also the code on takeovers, so that also known as the takeovers code. So that's also to protect the interests of the shareholders, especially the minority one as well, but not just for them. So if someone do come, let's say someone is interested in acquiring your company, and they offer to buy the shares of some of the shareholders at a higher price, but do not make the same offer to the other shareholders, that will be quite unfair. That will be against the interests of the other shareholders. So that's one of the main reasons for the takeovers code. Then we have the corporate governance code and report. So I briefly mentioned about this just before. So these are the one where they need to keep out the best practice of corporate governance. So there are some government departments here as well. There's the FSTB, Financial Services and Treasury Bureau. So that's very important. They play the role of overseeing all the financial matters. And I think in addition to the government budget, they also look at approval for different matters required under the regulations for company law. So for example, what are the requirements, for example, for the keeping of registers, for maintaining a company? Sometimes there are regulations concerning those matters, and they are also can be suggested by the FSTB. Then a very important department is the company's registry, because many, I would say all of the compliance requirements under CAP 622 is basically monitored by the CR. So every year you have to submit an annual return. If you have a change of location of your registered office, change in location of where you store your registers of members, or you have any change in directors or company secretary, then you must submit a form to the CR, the company's registry. The ORO, official receiver's office. So they are also very important, but they play a more important role for insolvency. Okay, so they are basically the department overseeing these matters, whether it's corporate insolvency or personal bankruptcy. Okay, then let's continue with the source of company law and governance, the importance of case law as a source of company law. So as I mentioned before, case law is very important because even though we have legislation, it may tell you a particular requirement, but how would you know exactly how to apply those requirements? So for example, Section 724, a member can lodge a claim known as an unfair prejudice claim. So what exactly do you mean by unfair prejudice? What would amount to unfair prejudice so that the court would accept my application or would issue an order to give me remedies? So in that case, you need to look at court cases where that section 724 was in fact applied, and then see under what circumstances that will be used. So you can see case law is very important. It supplements and also complements the legislation. The importance of constitution as a source of company law. So constitution we mean is constitution of a company. And you may recall earlier I talked about the internal rules, internal regulations of a company. That's sometimes known as the constitution as well. So in Hong Kong, for companies that is incorporated under Cap 622, we're talking about the articles. Articles of association of a company is basically the constitution of that company. Okay, it is the document that was basically there since you incorporated the company, and it was agreed upon by the members, the founder members of the company at the very beginning. So that's why it's a very important document. If you look, it said the relationship between the legislation and the constitution. Well, if you look at the company's ordinance, sometimes it would actually defer to the articles of the company. What does it mean? What do I mean by defer? I mean is it will say in your articles on this particular matter, is it covered in your articles? If so, refer to that. Okay, if not, go to part B. That's very common. Okay, so for example, I think it's for variation of class rights, it says something like that. It will basically say if you have an article, have a section in your articles governing how and whether you can vary the rights of a particular class of shareholders, then you will go to the articles. If not, then you go to section B, meaning then you refer to legislation. So generally speaking, legislation would have a higher ranking than articles, okay? Because one is legislation and another one is an internal regulation, okay? But if the legislation specifically say follow your articles, then according to the law, you follow your own articles. So that's why the constitution or the articles of a company is very important, because it's actually a source of law on some matters under company law, okay? Another thing, of course, as some of you may already know, is there are many different versions of the Constitution. Depending on when your company was incorporated, there may be the older version or the newer version. Also, when people set up their own company, they are allowed or they're permitted to have different clauses, meaning there's a template, there's a sample template that you can use as a starting point. But as long as you do not contravene the law, you can actually vary, add or subtract or amend some of the clauses. So that's why anytime you deal with company law with a company and you need to look at matters relating to the constitution of the company, then you must first check the articles of that company. Okay? Okay. Then the third bullet point, the importance of contracts as a source of company law. So these are special rules relating to companies entering into contract. So of course, you look at it, the importance of contracts. So anytime you have a business transaction, of course, you enter into a contract. However, if you have a limited liability company which is a separate legal entity. In that case, it is the company entering into the contract. Okay, it's not the person signing the contract, not the individual. It's actually the company entering the contract. So are there any restrictions on how those people can enter into a contract on behalf of the company? So that's why there are some special rules, and we'll be going through them later on. Then the corporate governance codes and reports talk about the relationship between company law and corporate governance. So people generally believe you set up a company to make profits. Okay, that's why you set up a company for business. But in modern days now, the expectations are higher, and you expect them, in addition to making profits, you also have corporate governance. So corporate governance in a lot of time is when you have the directors, you're managing the company on behalf of the shareholders. Are they exhibiting good corporate governance practices? Okay, and corporate governance quite often revolves around clear disclosure, being transparent, letting people know you're doing something, especially if it is outside the norm, outside the usual practice. And for some matters, you have obtained approval before you proceed. So those are good examples of corporate governance. The role of company law and the corporate governance report. So the CG reports, of course, is very important because it basically reports to the shareholders whether the company are following the good corporate governance practices. So if you go to the website of many companies, they always say they have good corporate governance. But how would you know they actually do practice good corporate governance? So the CG report will be a good source, because the INEDs, independent non-executive directors, they are the one quite often charged with monitoring the proper implementation of good CG practice. And CG reports usually publish once a year. So that's why the shareholders can be informed about that. So the CG code, as I mentioned before, is part of the listing rule, is Appendix 14. Okay, then you also have the international corporate governance principles. So the G20, OECD have their own principle as well. So needless to say, I think if you compare their version and the CG code that we have, you will see a lot of similarity, for obvious reasons, because we are an international financial center. A lot of our practices are internationally recognized. So even though it's different document and published by different bodies, I think a lot of good practice would be the same, if not highly similar. And then corporate governance and unlisted companies. So as I mentioned earlier, if you are a publicly listed company, of course you need good corporate governance practices, because you're answering to many public shareholders and investors. Okay, mainly, of course, is your existing shareholders. But what about unlisted companies? You're not listed, you do not have so many shareholders. Does that mean you do not need good corporate governance? And I believe you still need it. The reason is because if you are a small company, as in small in size and structure, it's entirely possible the directors and the shareholders are the same people. In that case, CG, corporate governance, may not be as important. But for a lot of private companies, they're still very sizable. Their business, the financials, still very high amounts. And the directors and shareholders may not be the same people, meaning they have a lot of investors, a lot of different shareholders, even though it's a private company. And the directors are sort of like managers. They manage the company on their behalf. Or some of the directors are appointed by the major shareholders. So in that case, you still have the shareholders' interest at stake, because it's different people. Directors, shareholders, not the same people. In that case, I believe corporate governance is still important, even as an unlisted company. Okay, so still on learning outcome 1, let's continue now with the second one, is business structures. So as mentioned earlier, there are different type of business structure. It is not just the limited liability company. So the most common 3 that we see from textbooks and articles is the first 3: sole proprietorship, partnership, and companies. Okay, so these 3 already would say, I believe, cover most, if not all, of the examples you see in practice. Okay, so let's start with the first one, sole proprietorship. So this is what we know as a unincorporated business. Okay, incorporated is where you have a limited liability company. If you do not have a company, you're running your business by yourself, it's your own business, then it's a sole proprietorship. Okay, so sole proprietorship in the old days, for example, sometimes you see a small store in a corner of the street run by the same family for many years. It's entirely possible. It's just a sole proprietorship, meaning they run their business on their own behalf. So in that case, there's no separate legal entity principle in that case. And of course, their personal assets would not be protected if the creditors go after the business for outstanding debts, which the business cannot repay. So that's sole proprietorship. But sole proprietorship is still quite common even in the professional field. So sometimes you see some CPAs or some lawyers, they're just starting out and they start their own business and they have not yet incorporated their business. Then in that case, most likely they're operating their firm as a sole proprietor. Okay? So now moving on to partnership. Partnership, the concept is almost identical to sole proprietorship, but of course it's more than one person. So for example, if it's a CPA, a group of CPA, they decide to run their own firm and they have not incorporated their business, then it's a partnership. Same with law firms and all that. It's entirely possible they have a number of partners running a business, that's a partnership. Then you move on to the third type, which is companies. If you look at the PowerPoint slide, there are many, many, many different types of companies. However, in most cases that you encounter, it will be the limited liability company. Okay, that's the most common. But by definition, there are other types, and so I will go through them with you. But just so you know, most of them, ones you will encounter, will be limited liability companies. Okay, in some jurisdiction, they call them LLCs. So let's look at the first sub point is registered and unregistered companies. So let's say if you incorporate your company under our CAP 622, our company's ordinance, you submit all the required form and make payment to the CR, the company's registry. In that case, you are a registered company. Okay, so that's very important because you are registered, then of course you get the protection of the separate legal entity. So you must follow the steps and procedures, submit all the forms, submit all the documents, and also make payment. The second sub-bullet point is public and private companies. So a lot of companies, if it's not listed, is limited liability, it will be private companies. So that one you encounter the most. So if you're not a private company, then you're a public company. Okay, it's important to understand public company and listed company is not actually the same thing. Okay, most public companies are listed company. That I can say, but not all public companies are listed companies. Okay, so what's the difference? Well, the biggest difference between a public company and a private company is a public company can offer the shares to the public, whereas a private company cannot. Okay, that's the biggest difference. Okay, however, if you want access to a vibrant market for the trading of your shares, if you do go public, then you would want to list on a particular exchange. So that's the reason why if your company is a public company and you want to offer shares to the public, most likely you will apply to be listed on an exchange. And that's the reason why most public companies are listed companies, but not all of them. Okay. So for example, if you are a publicly listed company and unfortunately you lost your listing status, then you will become an unlisted public company. Okay. Then you have the limited and unlimited companies. So limited, they mean limited liability. So it's entirely possible to have an unlimited liability company. However, it would not make sense to do so. So that's the reason why if you do incorporate your company, you would choose to have a limited liability company. Then you also have a parent company, holding company, and subsidiary company. So this is about the group structure. So if I have a company which owns shares, a controlling stake in another company, then I would be the holding company, and of course the one beneath me will be the subsidiary company. Okay, so it's also possible to call the holding company the parent company, but I think sometimes they call it holding is because sometimes one company may hold different percentage ownership in many different companies within a group. So that's why they will call it the holding company rather than the parent company. Okay, then moving on, we have the limited partnership fund, and limited liability partnership. So briefly, limited partnership, that's actually very common for private equity. And it's basically an arrangement where you have general partners and limited partners. So general partners are the ones who would manage and run the fund, I guess. And then limited partners are more the investors. They invest money in it. So why do you need the distinction? Well, since the general partner is the one who is running the business and making the decisions, the risk will lie with the general partners. In other words, they manage the business or the funds, but they have liability. Because as you know, partnership, if it is unincorporated, you do not have limited liability like a limited liability company. However, if you are a limited partner in a limited partnership and you were not involved in the management, then in that case, you can have limited liability. So it's sort of like trying to have a hybrid of the two and trying to get the best of both worlds. The second one is the limited partnership fund. So this one is where you can register with the CR, and then it's governed by the Limited Partnership Fund Ordinance. And as long as you're established in Hong Kong and your fund is domiciled in Hong Kong, then you may qualify for that. So it's a small subset of the different types of business structure you may have. Then the third one is the limited liability partnership. So these are mainly for firms. So as you know, partners of a firm, they do have the joint and several liability, and they do not have the separate legal entity concept applying. So it can be quite risky. If you have some firms that have many partners, maybe 10, 20 or more. So what do they do? It's hard for them to control every single partner. So that's why they have this specific setup of limited liability partnership. It basically protects the partners not at fault. So for example, if one or two partners they're involved in a particular case and acted negligently, but the other partners that were not involved, then it's entirely possible that the remaining ones can be protected as well. Obviously, this also worked at the same time concurrently with the professional indemnity insurance as well. I think that would also offer protection for the people who need to make a claim against them. Okay, then open-ended fund. So you can see we have many different types of structures now, and it's to try to attract different businesses and funds to come invest in Hong Kong or operate in Hong Kong. So the open-ended fund is the one that is regulated by the SFC. So it's mainly for those investment and securities matters. Then we move on to non-Hong Kong companies. So if you're a company that was incorporated under the company's ordinance, that would be a Hong Kong company. Okay, so non-Hong Kong company, because as you know, many companies not incorporated in Hong Kong do operate in Hong Kong. So in that case, if they under the ordinance, these are the ones which are known as the non-Hong Kong companies. And then small companies. So for some matters, for example, on annual reporting, for example, for AGM, it's entirely possible. I think it's more annual financial reporting. It's possible that if you qualify, then you may have exemption from some of the reporting requirements. So that's why you have small companies. Okay, so I've finished now talking about learning outcome 1, but I think it's more helpful if we can have some examples on how those topics might be examined in the previous exam. So that's why we have drawn up we've extracted some of the questions from previous exam papers. So for example, question 1 from the November 2023 paper, and here these two questions from the June 2023 paper. So these are just short questions, but I think it's helpful to illustrate these different topics. Okay, so let's now take a look at question number 1. Explain the difference between a private and a public company. So it's good to first look at the examiner's comments first. How well did they do? How did the candidate perform in 2023 that year? So according to the examiner, most candidates correctly refer to relevant section 11 of the company's ordinance. This is CAP 622. However, some candidates confuse a public company with a listed company. Candidates were expected to demonstrate an understanding that a public company can be either listed or unlisted, while a listed company has to be a public company. So I just explained that earlier, okay? So let's look at this in a bit more detail. So section 11 of the company's ordinance basically give you a good definition. What is a private company? Okay, because you want to know the difference between a private and public company. So it will be helpful to know what is a private company first. So under section 11 is saying in your articles, mean the articles of your private company, it restricts the members' right to transfer shares. So I mentioned this earlier as well, is I'm a member of the company, I own shares. Can I transfer to someone else? Can I sell my shares to other people? And the answer is you need to find out does it say in the articles. Are there any restrictions? The second part is you can only have a maximum of 50 members. So private company, unlike a public company, which can offer the shares to the general public, private company cannot. So there's a limit on how many members you can have. Also, a private company cannot make an invitation to the public to buy the shares, as I mentioned before. And also, private company, basically, you can only, they could have a share placement, or you basically negotiate with investors to sell shares in your company. Okay, so that's the definition of a private company under section 11. So if you go to section 12, what is a public company? A public company is not a private company. Okay, so that's the reason why it is so important to know the definition of private company in section 11, because the definition of public company in section 12 is if it is not a private company and not a company limited by guarantee, then you're a public company. Okay, so for the part here on the listed or not listed, I've explained already. So most important is understand is private company and public company is a type of company you can choose when you set up the company. But once you set up a company, for example, a public company, is a different decision whether you want to be a listed company or not. If you qualify, you can apply, and if approved, you become a listed company. So that's why all listed companies are public companies, but not all public companies are listed companies. Okay, let's now look at another question. Question 2 from June 2023 exam. So explain the difference between an unlisted company and listed company. So this one very similar to the previous question, but not exactly the same. So most candidates, according to the examiner, correctly pointed out that a listed company is a listed company listed on the Hong Kong Stock Exchange, and that it has to comply with the listing rules. So that's good. Most of them knew that. Many candidates also mentioned that a listed company has to comply with a greater number of disclosure requirements, and that is subject to a minimum number of INEDs, independent non-executive director, and also a minimum public shareholding requirement. However, those points did not carry any marks, given that they were standard requirement under the listing rules. So have to be very careful. In the exam, when you're under exam condition, it is understandable you may be a bit nervous, okay? And you may rush a little bit more. So that's why for an exam, despite the exam condition, despite the time pressure, you still need to be very careful, read the question carefully, and then make sure what you're writing down as your answer actually is answering that question. Because if it is not answering the question, no matter how much you write, no matter how many pages, the markers looking at that, very difficult to give you any marks. So that's why it is important to slow down a little bit, read the question carefully, and while you're answering the question, it does not hurt to ask yourself just once or once in a while. Am I answering the question? Just double check. In this one, difference between listed and unlisted company. So those very specific requirements of a listed company may not answer the question because it's asking you to explain the difference between listed and unlisted company. So that's why unlisted company can be a private company or a public company, as I mentioned earlier, but a listed company must be a public company. Okay, so I think that's what the examiner was looking for. Okay, now let's look at the third question. List 5 types of company that can be incorporated under the company's ordinance. So the examiner commented that most candidates were able to point out 3 types, specifically private companies limited by shares, public companies limited by shares, and companies limited by guarantees. So you recall earlier I mentioned these 3 most common would cover most types already. So understand why most candidates got this correct. However, the remaining 2, we rarely hear about them because people rarely use them. Is the private unlimited companies with share capital and public unlimited companies with share capital. So have to be aware. If you see a question asking you for 5 types of companies, then in addition to the 3, if you can remember, then write the remaining 2 as well. However, if you cannot remember, then move on to the next question. Okay? These questions in section A, they are only worth 5 marks. So do not push yourself to, I need to try to work out which are the remaining 2. Do not do that. It's only worth 5 marks. If you know it, write it down. If you don't know it, move on to the next question. Okay? So some candidates mentioned sole proprietorships and partnerships, which are, however, not incorporated under the company's ordinance. So you can see the question lists 5 types of company that can be incorporated under company's ordinance. So since sole proprietorship and partnerships are unincorporated business structures, they would not be incorporated under the company's ordinance, and that's the reason why the examiner said would not be correct to answer them, and if they did write that part of the answer, would not score any marks. Okay, so now we can look at incorporation and corporate personalities. So here you can see is there are some more detailed topics underneath. Is promotion of a company, pre-incorporation, incorporation contract. So you can see all these topics relevant to the very beginning when you first start off with your company. So let's first look at promotion of a company. So promotion, what does that mean really? Well, it's basically saying that you are the one, I would guess, trying to start up your company. So that's why with promotion, it would be trying to find investors. That's one example of promotion. Another one, of course, is you're the one who is actually filling in the forms and submitting them to the authorities, for example, the CR. So that would also be part of promotion. So all the people involved in the setting up of a company will be a promoter of a company. Okay, so why is that important? Well, imagine you're starting a new company for your business, and it takes some time to set up your company. Okay, so that's why it's entirely possible sometimes you want to get started with some of the business matters first, even before everything is finalized, before everything is formalized. So if the promoter, let's say, enter into a contract on behalf of a company, then would the promoter be responsible? So we'll be looking at that in a pre-incorporation contract. But what if the promoter, who is aware of the business that the company will embark upon, and he or she actually went ahead to buy a particular property that the promoter knew the company once set up will purchase? In that case, is it possible the promoter may have done something that's in the interest of the promoter, but not in the interest of the company about to be formed? So that's why promotion of the company or the role of the promoter is quite important as well. Okay, so then to pre-incorporation contracts. As I mentioned before, it's entirely possible for the promoter to enter into a contract on behalf of a company before a company is formed. So I'll give you a very simple example. Let's say you want to start a new restaurant and you intend to set up a company to own and manage that restaurant business. So before everything is done, you are keen, you want to get everything ready. The sooner you can start running your business, the sooner you start to make money, have some income, then you can have some profits to offset the costs. So let's say you enter into a contract to buy some wine. You enter into a contract to buy some food. You enter a contract to buy some tablecloth, or enter a contract to hire some of the people to work there, maybe the cook or the waiter, the people who will be working in the restaurant. Now, once a company is properly formed, you have the separate corporate personality, then yes, it's the company that entered a contract. But if it's the individual who entered a contract before a company was born, okay, before the company was properly incorporated, then you cannot have separate legal entity. And it's hard for you to say that contract belongs to the company. So if something goes wrong and the other contracting party comes to sue the company, then the company can argue it's a pre-incorporation contract. The company was not yet formed. You cannot hold me accountable and legally liable for a contract to have contractual obligations when I was not yet born, wasn't even born yet. So that's why this is a quite interesting topic, because in real life it's entirely possible. But of course, nowadays, the time it takes to set up a company is much shorter than before. So that's why the best advice a professional can give to their client is make sure you form the company first before you enter into contract. That would be their best advice, rather than risk going into the area of pre-incorporation contract, which sometimes can go your way, but other times may not, meaning the outcome may not be the outcome you prefer. So that's why, if possible, better to incorporate your company first. Now, in practice, of course, there are ways around that problem. In addition to the fact that it's now very fast, you can set up a company, there's something called shelf companies. Okay, so shelf companies are companies that are already set up, already incorporated, already registered. So if you buy them from a professional firm, from a company secretarial firm, then you do have the separate legal entity, okay? But then you do have a tiny bit of risk because you wonder, okay, did that company enter into any contracts beforehand? If so, the liability will follow the company, but that's a separate matter, okay? So, okay, then proper incorporation of a registered company, of course, you must make sure you follow all the procedures and requirements as stated in the company's ordinance and procedures and guidelines provided by the CR, okay? So in most cases, you will need to fill in an incorporation form. You need to clearly identify who are the directors and who are the founder members. So members of the company are the one who will be the owners of the company, or for example, hold shares in the company. The founder members are the first set, those people who initially agreed to be members of the company. Who is the directors, who are the members, who are the company secretary. You fill in the form, you pay the fee, and you also have a copy of your articles of association. So submit them to the CR, and then if they believe everything is in order, your company is properly set up, then you've incorporated your company, okay? And it's registered, most important. Okay, then you have the corporate personality. So I mentioned this briefly before. Is once your company is properly set up and registered, based on Solomon and Solomon, you have separate legal entity. A contract entered into by the company, it belongs to the company, and if there's any problem, the creditors can only go after the company's assets. It cannot go after the assets, the personal assets of the directors or personal assets of the shareholders, cannot go after the individuals, can only go after the company. So that's why it's important to make sure the company is properly set up, then you do have the corporate personality, get the protection of separate legal entity. Okay? As I mentioned earlier, is separate legal entity will be the general principle, but there are exceptions to the general principle. For example, in some case, the court would lift or pierce the corporate veil. Okay, so what's the difference? I notice those two terms quite often used interchangeably. So I think it just depends on the context. So if, excuse me, if you want to see who is behind the company, who is behind the corporate veil, then that's known as lifting the corporate veil. So for example, people dealing in a company only see the company, the entity, but who's actually behind. So lifting the corporate veil basically can see who's behind. But piercing the corporate veil, from my own understanding, is in the context of cutting through the corporate veil, going through the company, so that the individual will be liable. Okay, so they mean about the same thing. Is basically overriding the separate legal entity concept. Okay, then you have corporate liability. Corporate liability, as I mentioned, if a company enters in a contract, then it is the company that will be legally liable. So that's what they mean by corporate liability. So that's very important because, as I mentioned before, is if the company gets into financial trouble, cannot repay their debts to the creditors when they fall due, of course, the creditors can claim against the company. So then you need to ask, how much assets do the company possess? How much assets do the company own? If there's enough assets, it is fine. The creditor will go through the courts or other avenues and they can claim against the company, get the money back. But quite often, in a poor financial situation, the company may not own enough assets to repay all creditors in full. In that case, the creditors wants to be repaid. So how? How can the creditor get remaining payment? Well, most likely we want to go after the individual. We want to go after, for example, the shareholders, the owners behind, so they have personal assets. And if you do not have the separate legal entity, you don't have the difference between individual liability, personal liability, and corporate liability, they can go after you. So that's why it's important to have the differentiation, the separation between the two. Okay, so let's look at some questions as an example. Let's see. Question 1, June 2024. So what is an incorporation contract? How can a company be bound by a pre-incorporation contract? Let's look at the first one. There are quite a lot of questions. So here we have the examiner's comments. So candidates were required to explain the meaning of a pre-incorporation contract and how a company can be bound by such a contract. Most candidates correctly refer to some of the relevant concepts, including novation, implied contract, by conduct, and by ratification. So as I mentioned, this is a very interesting and also very important contract, important topic for company law. So in terms of the pre-incorporation, as I mentioned before, it is the contract entered into by someone, usually the promoter, before the company is properly incorporated, before you submit all the forms and you're properly registered with the CR. So most candidates understood this, and that's important. They also need to understand it's based on the relevant legislation. You need to go back to the relevant sections and you need to ask, okay, then in this particular situation, who would be liable? So let's say if they enter into a pre-incorporation contract, would it be the company that's liable or the person who signed the contract that will be liable? So here you can see is basically, in most cases, it will be the individual. And the reason is because the company was not yet born. It's not yet incorporated. So how can you hold someone or something responsible or legally liable before it exists? So I think most of them understood the legislation part. And of course, in addition to the legislation, you also need to understand the court case. So Kellner and Baxter will be one often quoted. But that one is if you really know these individuals are the one you're signing the contract with, they're the one you're selling the wines to, then of course when it comes to payment, you go after the individual and not the company, especially if the company doesn't have assets. So that is very important. Relevant concept is novation. So what is novation? So novation is basically if you have a company that's properly set up and you have a pre-incorporation contract. So the company is not part of that contract yet. So, but you actually want it to be your contract. So what do you do? So the best thing or easiest thing to do is basically say, we want the contract, we want to transfer the legal obligation to the company. So in a way, it's sort of like having a new contract to replace the old contract. The old contract is the other contracting party with the signer of the contract, the promoter. But now I want this to be the company's contract. Both parties agree. So in that case, the new contract is where it is between the other party and the company. Implied contract by conduct and also ratification. So sometimes express and implied, the difference is express is when it's clearly stated verbally or expressly in writing, whereas implied is it's not clearly stated but it's understood by both parties, in particular based on the conduct of the parties and circumstances. You understood that was the agreement. So maybe it's already implied this contract will belong to the company. That's a possibility. And the final one is ratification. Okay, so what does it mean by ratification? Ratification is basically even though the individual, for example, signed a contract but did not have authority to do so, and the company has every right not to admit liability for a contract, it's possible for the company to say, I want this contract. Even though you did not have authority, we will still accept the contract and recognize the responsibility. That's ratification. Okay? Anytime, for example, officer of the company acted without authority or beyond authority, it is possible for the company to say, but we will ratify that. Meaning it's still okay, we will still accept the responsibility. Okay, so what restrictions exist in relation to a company's name? So according to the examiner, candidates were asked to describe the restrictions in relation to a company's name. So most candidates were able to explain the relevant restrictions, including a name that is the name same as the name appearing in the index of companies. So that's most important. Is if you set up a new company and you want to know what is the name, which name you can use, of course you cannot use the same name. So that's the reason why they have this requirement. And also same as body corporate incorporated under an ordinance. So that basically means if there was another entity already have that name and it was set up under a separate ordinance governing their particular industry or area, then of course you cannot use the same name. Also, where the use of the name would constitute a criminal offense. Okay, so you may wonder how can a company name be a criminal offense? So the example I often use is a criminal offense to say you're a member of a triad, for example, the gangsters. Okay, so if you call yourself number one triad company limited, then I think there's a chance you may have committed an offense. So in that case, if you apply to have that name for your company, I would say quite likely the CI will say, no, you cannot do that. Also, if the name is offensive or otherwise contrary to public interest, cannot as well. Okay, what is a shelf company? Explain the advantages and disadvantages of such a company. So I briefly talked about this earlier, so you should be familiar with this as well. So most candidates correctly pointed out that a shelf company is a dormant company with no business and accurately defined its advantages. So what is a shelf company? As mentioned before, it's a company that's already set up and registered, most likely by the professional firm or the company secretarial firm. Okay, so once it's registered, of course, it's sitting on the shelf, so to speak. It's not doing anything. So most likely they would have applied for the company to be dormant. Okay, so why would you want to apply for dormancy? Very simple. Cost saving. Okay, compliance is costly in terms of time and money. Since your company, you're not using it for anything, it's just sitting there waiting for people to buy if they need it, in that case, you apply for dormancy. So there's no business, and there are clearly advantages to doing that, because then it's very, very short waiting time. Okay. However, only a few candidates were able to describe the disadvantages of a shelf company, specifically that a shelf company is not tailored to the needs of its promoters, and the promoters need to change the name and its articles or share structure, so on. So is a shelf company, it has a standard setup, standard structure, and standard set of articles of association, of course, okay? You would not have 10 shelf company with 10 difference, okay? The only difference, of course, is the name. So when they first set up the company, they would need to name the company. So they will try to think of some nice business names. You think it's good, there's no need to change your name. But it's not the name you want, then of course you need to change it. But if you change the company name, it has the same restrictions. Remember in an earlier slide, we said, if the name already taken by someone else, you cannot take it. If it's a name that's, let's say, offensive or whatever, you cannot use it. So that's why there are some restrictions. Articles. So the company would set up with articles, a standard version. So if you purchase a shelf company, you can amend the articles, okay? But it's just something extra you need to do. You need to have the shareholders to pass a special resolution. In order to do that, you need to fill in the form and submit the amended version to CR before it becomes effective. So that's the reason why you have to have it registered first. So that's the reason why they say it's a slight disadvantage. Well, it is a disadvantage because you need to make changes. Same with share structure, but I guess that's what happens when you buy a ready-made or ready registered shelf company. Okay, then another question. Explain the meaning of corporate personality and what's the consequences. So candidates were asked to explain the meaning and the consequence. Most were able to identify and the relevant concept and consequence. So as I mentioned before, it is so important. It's basically linked to the separate legal entity principle. Once you properly set up a company, then the company acts for itself. It owns assets and it is responsible for its own liabilities. So that's why in most cases, it would protect the owner of the business because the creditors cannot go after your personal asset. But at the same time, that means there are limits on what you can do. For example, if the asset belongs to the company, individual shareholders cannot go take the asset for their own use, especially if there are other shareholders involved. So that's why you have the corporate personality and also you have the separation between company assets and personal assets. Okay, then let's look at the next question. In what circumstances will the court disregard a company's corporate personality? So candidates were required to discuss the circumstances under which the court would disregard a corporate personality. Only a few of them were able to provide the information or refer to relevant rules and cases. Most candidates simply explain the concept of corporate personality, but not the grounds under which the court will lift the corporate veil. So this is quite interesting because this question, in a way, should be an easy question. Because based on the examiner's comments, you can see this question is asking about the separate legal entity principle, the general principle, and it's asking you the exception to the general principle when the court would disregard the company's corporate personality. So for example, when will the court lift or pierce the corporate veil? But I guess maybe because of the wording, some of the candidates not so familiar, so they did not write down the answer. Okay, so I think it's important to understand the same topic. Sometimes they can describe it with different words. So instead of asking you, when can a court pierce the corporate veil? Another way of asking is when will the court disregard a company's corporate personality? You're still asking for the same thing. So that's why for the general principle, as I mentioned before, Solomon. If a company is properly set up, incorporated and set up and registered, then you have separate legal entity and the assets of the company is separate to the assets of the individuals who own and run the business or own and run the company. Okay? When will the court disregard the corporate personality? When will they lift or pierce the corporate veil? So Gilbert Moulton and Horn, that's one of the most famous case, which provided the grounds on which the company or the court will pierce the corporate veil. Is very simple. Why would they want to do that? Why would the court want to have the exception and override the separate legal entity principle? Well, generally speaking, if they're abusing the corporate structure, they're doing something wrong. Okay, so the corporate structure is a good thing to encourage people to do business. But if you use it for the wrong purpose, then in some situation, the court will not allow you to do that. So for example, if the individual was using the company structure, a limited liability company, to evade their legal obligations, then the court will say, no, will not allow you to do that, will pierce the corporate veil, look right through the company and hold the individual legally liable. Okay, so in Gilbert Moulton and Horn, we had a managing director who signed an agreement saying a restrictive covenant saying that he will not if he leaves the company, he will not set up another company and will not compete against the company. So it's a non-compete clause, basically saying, I promise if I leave, I will not compete against you. So why would someone need to sign that? So imagine if you're in a senior position of a company, you have access to confidential information and you have access to the list of customers. So if you leave the company and if you wrongly took the list of customers with you and you contact the customers and say, I have a new company, why don't you give the business to me from now on? So that will be detrimental to the original company. So, so what has this got to do with the piercing the corporate veil? Well, the managing director, he thought he was clever. He did not run the new business. It was a company that ran the new business, and he was not the director or shareholders of that new company. I think his family members and friends were. Okay, so that's why the court need to look at the whole circumstances, and in the end, they concluded that you were using a company structure to evade your legal obligation. So what was his legal obligation? He promised not to compete with his previous company. Okay. Okay, so let's now look at the next topic under Learning Outcome 1, legally binding the company. So how companies enter into contracts, company seal. So you may have watched on TV or on the movies in the old days, they sign a contract or a particularly important document, they have some wax and they have a seal, a metal seal that they would stamp onto the document and that becomes official. Okay, so company seal was used under company law a long time ago, but almost 10 years ago, 2014, when we had the CAP 622, it was also decided that company seal is now optional. You do not need the physical seal to do the stamp, and even if the document requires sealing, you can just do it by words. This document is now sealed, so that's why it's no longer a requirement. Constitution of a company, as I mentioned before, that's the internal regulations of your own company. So that's a very important document. For most company that was incorporated in recent years, it will be the Articles of Association. Okay, so why did I say most companies? Because if a company that was incorporated a long time ago, you have something called a Memorandum of Association and Articles of Association. So abbreviated as M&A. Okay, but nowadays, if it's a company incorporated under CAP 622, you only have the Articles of Association. So now, then you have the model articles. So as I mentioned, there's a sample set, there's a template provided to you with the ordinance, with the company's ordinance. That's known as the model articles. So there are model articles for private companies, model articles for public companies, etc., etc. I think there are 3 sets at least, okay? So now, why is it important to know there are model articles? Because it's the default articles, okay? It's very important to know that is if you set up a new company and you do not want to write your own articles, then you can adopt the model articles for your type of companies. So very convenient, very fast. You do not need to draft it yourself, okay? However, especially if you're advising on this matter, You have to be very careful. Why? Because once you incorporate a company with the model articles, they become binding on the company and all of the members. So make sure you are aware and familiar with the different clauses in the model articles. Quite often, people do not pay attention to the articles until something goes wrong. Then they refer to it and realize it's not what they wanted. So I have to be very careful and make sure you know what exactly is the content. In practice, a lot of companies would adopt the model articles, but then they may add clauses, they may subtract clauses, or amend some of the clauses in the model articles. That is entirely permitted. As long as the change do not contravene the company's ordinance, it is allowed. Okay, so what does it mean by altering the articles? Okay, altering the articles means once you incorporated your company, you have one set of articles. That's the final version. Even if you make some changes, that's the final version. And that's the version that was submitted, or a copy of that version was submitted to the CR when you apply to incorporate your company. Now, it's entirely possible after incorporation, the shareholders may wish to alter the articles, add some clause, delete some clause, or amend some existing clauses. In that case, then you must go through the proper procedures. So section 88(2), if you want to amend the articles, you need to have shareholders special resolution where you have shareholders to vote, and you need 75% or more of the votes in order to pass that resolution. Okay, so that is very important. You must do that. And then even if you do, then you also need to be aware of the requirement of the Allen and Goldreeve. We will go through that in a bit more details later, and in order to have the alteration take place. Now, what about class rights? For most companies, they will only have one class of shares. So in most cases, it's ordinary shares. But it's entirely possible for some companies to have different classes of shares. Maybe they have A shares, which may have higher voting rights, or some A shares may have different payment terms or different dividends, also known as preference dividends. In that case, then you have more than one classes of shares. So why is that important in the context of altering your articles? Well, if you are altering the articles and you happen to alter the rights of shareholders of that particular class of shares, then you need to follow the ordinance and you have to basically get the approval before you go ahead. Okay, then you have agency and authority of agents. So even though you have separate legal entity, and the company is a separate legal person to the individuals managing and owning the business, at the end of the day, the company still requires individuals, people to act on its behalf. So for example, to negotiate on a contract or to physically sign a contract, a company cannot do that. It's a legal entity, it's recognized by the law, but it does not physically exist. It has no hands. It cannot go anywhere by itself, cannot sign any documents, cannot negotiate. So that's the reason why it would need agents to act on its behalf. So that's why in the context of company law, in most cases, the agent will be the director. But it's entirely possible it can be other people as well. But that's why the law of agency is important. Agency law is relevant to company law in this particular context. So if you have agents acting on behalf of the company, naturally you want to ask, so is the company bound by the acts of the agents? So if the agents sign a contract, is the company liable? So often the first question you want to ask is, do the agent have authority to act on behalf of the company? So when it comes to authority, there are different types of authority. There's the express actual authority, which means you clearly stated, for example, on the appointment letter, that you have authority to act on my behalf, and this is the scope of your authority. These are the things you can do. That's the actual express authority. Okay? But there's also implied actual authority. What does that mean? That means even though there's nothing in writing, I did not really expressly appoint you as my agent, but is it possible the way things are conducted, the way the board of directors have conducted, that they have allowed a person, for example, the managing director, to believe he has actual authority to act on behalf of the company. So that's possibility number one, have the implied actual authority. But another possibility is there's apparent authority. So that's why express actual authority and implied actual authority, these are actual authority you're arguing if you want to say it's binding on the company. But there's another class of authority known as apparent authority, which admits at the very beginning there's no actual authority, but a contract should be binding anyway. So how is that possible? Well, it's basically based on the Freeman and Lockyer case, which basically say you can satisfy all three conditions, then it is possible that this person without actual authority did have apparent authority. So the mindset of the apparent authority is how you represent it to the outsider. Okay? If you represent it to them and it appears that this person, based on your representation, did in fact have authority to sign contract on behalf of the company, there's no reason for the outsider not to believe your representation. There's no reason for the outsider to think this person did not have actual authority, even though this person really did not have actual authority. So apparent authority is quite interesting because it can happen in real life, but it's a situation where someone with no actual authority can actually have apparent authority and a contract can be binding on the company. Then we move on to indoor management rule. Okay, so this one is similar to apparent authority, but here is actually talking about your own internal regulations. So on the same mindset, an outsider, it's very difficult for them to know what's going on inside your company. So even if you have internal regulation restricting, for example, the scope of power or scope of authority of a particular person to sign contracts, it's difficult for the outsider to know. And that's why it is there to protect them. So there's the statutory indoor management rule, and there's also the common law indoor management rule. So statutory, of course, is by the sections in the ordinance, whereas the common law is based on the Turkens case, and that's why it's called the Turkens rule. So in that case, it's basically saying is if it appears that you actually do have authority to sign contract, but there might be an internal rule limiting your power on how much you can sign contract for. So for example, the internal rules say you can only sign contract up to 1 million, but you only have authority to sign up to 1 million, but of course, maybe you sign a contract for 3 million. Then if the other contracting party argues indoor management rule and satisfy all the requirement, it's entirely possible the contract remains binding on the company despite the fact that the director who signed the contract only have allowed to sign up to 1 million, but the contract is for 3 million. So that's basically the indoor management rule. Okay, so then we have ratification. I've already explained that earlier. It's basically you did something beyond your authority or outside your scope, and the company is basically saying, despite that, we think it's okay. We will still recognize the contract. That's ratification. So despite all these problems here with the internal regulations and with the authority, if the company wants the contract, maybe it really did want to sell the item or good or want to buy a certain good or whatever, then it can ratify the contract, which means we will recognize the contract, we will recognize the obligations and also the rights of the contract. Okay, so let's look at question 2 of the November 2021 paper. A company's constitution forms a statutory contract between certain parties. Explain who the parties to this statutory contract are and describe how it differs from a standard contract under common law. So contract is normally governed under contract law, and it governs the parties, or it governs the contracting party. So if I enter a contract with you, then we have a contract governed by contract law, and it is binding on you and on me. Okay. Now, statutory contract is similar, but the force of law is not just under contract law. It's basically governed by the legislation. That's why it's statutory contract, and it's formed at the time when the company was set up, when it was incorporated. Okay, so you will recall I mentioned the concept of founder members. Okay, they are the members who were there at the beginning when the company was formed. They have agreed on the contents of the Constitution, the Articles of Association, so that now becomes binding on the company and all of its members. That's the reason why they call it a statutory contract, because it comes into force when you form the company, when you have the articles, and then of course, you're the one who agreed to be bound by them. So that's why when they say who are the parties involved, then clearly it's the company and all of the founder members. Okay, they are bound. Okay, now it's an interesting concept because the parties to the articles, the parties to the statutory contract can change. So for example, if I was a shareholder in a company and I decide to sell my shares to someone else, so I'm no longer a member of the company after I sold my shares. So I'm no longer bound by the statutory contract after for matters after I left the company. However, the new shareholder, the person who purchased the shares from me, becomes a shareholder, becomes a member of the company, and then will be bound by the Articles of Association like other members. So this one is quite interesting because you can imagine if I sign a contract with you, it's binding between the contracting parties. It would not bind a third party or someone else, usually. So that's the reason why it's quite different. So in this particular context of a statutory contract, another thing very important is only the company or the members can enforce the clauses in the articles. Okay? So what does it mean by enforce? It basically means enforcing my rights under the articles. So you have a contract is something they promise to do. If they do not do what they promise, I would want to enforce that article, meaning I want to say you should do what you promise or as promised in the articles. Okay, so it's quite important to know is for members, the individual hold shares, only in their capacity as a member can they enforce a clause in the articles. Okay, what does that mean? It means an individual can wear different hats, can act under different capacity. So for example, for a smaller company, it is possible that the directors and the shareholders are the same people. Okay, so in that case, one of them at times would act as director of the company, and in other times the same person may act as a shareholder of the company. How would that work? For example, if that same person attended a board of directors meeting and voted on certain matters, he was voting as a director. He's not voting as a shareholder. So if that same person subsequently attended a general meeting to vote on a resolution, okay, let's say a special resolution whether to alter the articles or not, in that case, when he casts the vote, he's casting as a shareholder and not as a director. So that's capacity is important, and that's an example. And if you want to enforce your clause in the articles, you can only do so in the capacity of a member. You cannot do it, for example, in the capacity of a director. Okay? Right. Okay, so another question, question 2 from the November 2021 exam. So a company's constitution forms a statutory contract between certain parties. Explain who the parties to this statutory contract are and describe how it differs from a standard contract under common law. So my apologies, I think I might have covered some of this, but doesn't matter. We can repeat it in the context of this question. So according to the examiner, candidates were required to explain the concept of a statutory contract and that it is formed between a company and its members, as well as between its members. So that means is when they enter into the articles, once the articles is finalized and they form the company, it is statutory contract between the company and each member, but it's also a contract between its member and the other members. Okay, So that's an important concept to know. It's binding on all parties, the company and the member, and also the members in between each other as well. So most candidates currently define the relevant parties. They will also expect to describe some of the major distinctions between a standard contract and a statutory contract. Only a few were able to distinguish between the two types. So a statutory contract is the articles that was formed under the company's ordinance when they finalize the articles and incorporate the company. Whereas the standard contract, so to speak, is the contract that is entered into between the contracting parties, maybe between me and you, or maybe between more than two people. But at that time, it's very clear who would be the contracting parties. Okay, when you signed the contract, you knew how many people were involved. And a standard contract, of course, is governed under contract law. It's not governed under company law, so to speak. Okay, so in that case, it's very important to know the difference between the two. And as I mentioned before, with the statutory contract, when I sell my shares to someone else, that new shareholder becomes party to the statutory contract and is bound by the obligations in the articles. Whereas under a standard contract, we sign a contract, the rights and obligations between the two of us. Okay? Even if I sold the goods to someone else, for example, I enter a contract to buy something from you, and then I sell that same item or good to someone else, it's under two separate standard contracts. You cannot say, because I sold the item to someone else, the buyer becomes a contracting party to our original contract. No, that would not happen in a standard contract, but it would happen in a statutory contract. Okay, so we have finished learning outcome 1. If you want, maybe you can pause the recording now and just take a break before we move on to learning outcome 2.